When an officer arrests you for DUI in California and you take a chemical test, your physical license is taken and you are handed a pink form called the DS-367. That document is a temporary California driver's license, and for those 30 days it is fully unrestricted. If your license was valid at the time of the arrest, you can drive anywhere, at any hour for any purpose, with no work-only condition attached. Even if you refuse the chemical test, the 30-day window does not shrink and no restrictions attached to it during that period. What a refusal changes is the suspension that arrives after day 30, which runs longer and generally carries no restricted license option. Most major rental chains run your license through a motor vehicle record check at the counter. Common automatic disqualifiers include a suspended or revoked license, any DUI conviction within roughly the past 3 to 5 years, and a license that does not match the standard format their system expects. A pending arrest without a conviction may or may not appear depending on the database they use. The practical catch during your 30-day window is that some counter agents refuse to accept a temporary permit because their system needs a standard card to scan. Call the rental company before you show up so you are not stranded at the counter. Once your 30 days expire, your license is suspended unless you or your attorney requested a DMV administrative per se hearing within 10 days of your arrest, and that hearing is still pending. Requesting the hearing in time can preserve your full driving privilege while your case works through the courts, sometimes for months. Missing that 10-day window generally means the suspension takes effect automatically on day 31. That single deadline is one of the most important actions in the entire case. A restricted license after a DUI typically allows driving to and from work, to DUI school, and for employment-related purposes during work hours. It does not give you an unrestricted right to rent a vehicle for any trip you choose. Most rental companies will decline a restricted license outright, and even if one does accept it, driving the rental outside your approved purposes could create additional legal problems. A separate challenge arises if your license carries an ignition interlock device requirement. Rental cars do not have ignition interlock devices installed, and California law requires you to drive only vehicles equipped with one when that condition is attached to your license, so a standard rental would violate that requirement. 2 coverage sources you may count on can disappear quietly after an arrest. Some personal auto insurers cancel or non-renew midterm once they learn of the arrest, and if your policy lapses, the liability coverage that normally extends to rental cars goes with it. Separately, many premium credit cards offer rental car collision coverage as a cardholder benefit, but a number of those policies exclude drivers with recent DUI arrests or convictions. Check your cardholder agreement before you rely on that benefit, because clearing the rental counter does not mean you are covered if something goes wrong. If renting is not an option right now, rideshare and public transit keep you moving without adding risk to your case. I'm Joel Brand, a California DUI lawyer. This is general information, not legal advice. If you want a free written case analysis, it is at DUI.guru.